Whether you're thinking about your own estate planning, or maybe you're watching this because you recently lost a loved one and they died without a will, a lot of people contact us wondering what happens when somebody dies without a will. So today we're going to talk about both the process of what happens and also a little bit about who actually inherits when there's not a will in place. When someone dies without a will, the exact steps and process will vary a little bit from one estate to the next, depending on what the person owned when they passed away. Now, most people have some accounts that have beneficiary designations, whether that's life insurance or things like retirement plans. And for those accounts, we don't need a will because they have those beneficiary designations in place. So usually the beneficiaries can just contact the company to determine what paperwork they need to submit in order to claim those accounts. But most people also have assets that don't have beneficiary designations on them. Things like bank accounts, investment accounts, real estate, automobiles, maybe even some business interests. When there's no beneficiary designation in place, then we have to go through a court process called estate administration, or a lot of times people refer to this as probate. And this process has a few different steps involved, and so it usually can take about a year to go through the whole process. So let's talk about what that looks like. So the first step to kick off the process is a surviving spouse, adult child, or next of kin will petition the court to be appointed as the administrator of the estate. Now, you might be familiar with the term executor, but that's somebody that was named in a will. So when there's not a will, we call them an administrator instead. The court will appoint the administrator, and then the first thing that person has to do is prepare an inventory of the estate and figure out what is actually part of that estate. Now, I know that can sound straightforward, but sometimes that can be kind of difficult, especially in today's world of online banking. It can be challenging just to figure out how have we accounted for all of the assets that are part of this estate. And then the next thing that administrator does is they have to take care of any debts or claims against the estate. And because there may be claims that we're not aware of, we have to publish a notice in the newspaper called a notice to creditors. Maybe you've seen that in the back in the classified sections, all those estate notices. That's what those are about. And when we publish that notice, we have to give people at least 90 days to respond and come forward and say, hey, I have a claim against the estate. Now, once we have all those claims, the administrator then has to settle them, figure out which ones are legitimate claims, and make sure that they get paid before we distribute any assets from the estate. And once we've taken care of all those claims, we have to figure out how the remaining assets get distributed. Now, the administrator doesn't just get to decide how we're going to allocate them or what they think is fair. When somebody dies without a will, North Carolina has default laws about how those assets are going to be distributed. And unfortunately, one size fits all usually means one size fits none, meaning that these laws don't distribute the estate the way most people would anticipate. Let me give you an example. Most married couples that we meet with tend to assume that if one of them died, everything would go to the surviving spouse. But in fact, that's rarely what happens. If that deceased spouse doesn't have any children, but has parents that are still living, then part of the estate would go to their spouse, but part would actually go back to those living parents. Now, if the deceased spouse has children, then instead part goes to the spouse and part goes to the children. And if those children are minors, it gets even more complicated because minors legally can't own anything. So the court would appoint a financial guardian to manage those accounts until the children turn 18. And then at 18, those accounts just get handed over to the child. Now, I don't know about you, but most of our clients don't think 18 is a smart age to turn the accounts over to the kids. Not to mention, that's going to make things a lot more challenging for the surviving spouse who's still trying to manage the household. The bottom line is each estate will be a little bit different in terms of the exact filings that are needed, but overall, the process usually takes about a year to complete, and the assets may not end up with the people we expected them to end up with. So if you're watching this video because you don't have your own estate planning in place, then do your family a favor and make that a priority. But if you're watching this video because a loved one recently died without a will, give our office a call. We'll get you set up with our free guide to understanding estate administration, and we'll help you figure out your next steps for moving forward.